I'm not gonna go through. What's up, everybody? This is Keng El Bey, and for the talk, I'm gonna get into. I put in the book How to Stop Child Support, so I'm gonna break this down. So this was my case a while back. Now I redacted some of my stuff out of there. So just to let you know, this is what happened. They put on me a no charge child support lien. This is what they did. They put a lien on me. But when we went through the motions and did everything, they had to release the child support lien. My daughter still isn't grown yet. So just to let you know, this is what you gotta do. This is what you gotta learn how to deal with your case and deal with it right. So I'm gonna show you how you got to win your case, how you got to fight your case, and how to get your case done. So just break this down. This is what I was fighting. Child support. Yeah, I never really talked about my case because a lot of people, this stuff that I'm talking about is very, very old. We don't even do this process no more. But I'm gonna tell you, see, when you boots on the ground, you know how to litigate. Most of these cats that's talking about child support, they put in all this other stuff. I'm gonna show you what I was doing. So this is what they were arguing. This is what they were arguing on the case. They was arguing this. She didn't argue anything, but they were saying that she had custody, blah blah blah. I said no, she didn't. I said she couldn't have custody because my daughter had been rocking with me for a while. So I had all my credentials. I put everything into evidence. So when you're dealing with evidence and affidavits, you got to get your affidavits authenticated. You can put them in, but I like to get mine authenticated. And my evidence, I like to get done a particular way also. And then you have to rock with them according to exhibits and everything. So they don't give a father any rights. An unmarried female who gives birth to a child is the sole residential parent and legal custodian of the child until a court of competent jurisdiction issue an order designating another person as the residential parent and legal custodian. A court designating the residential parent and legal custodian of a child described in this section shall treat the mother and father as standing on equality when making this decision. So, I tell brothers right here, I had the court stay the proceedings based upon this motion. I had the court to I had to make them stay child supports on the grounds because I felt like I was deemed the custodial parent based upon that I was using the child. The court I argued the best interest of the child standard, best interest of the child, Ohio. Standard, Ohio. So this is everything that this is stuff old though. This is super old. It says the best interest of the standard in Ohio. I'm just going best interest of the child. So this is what they use. This is the standard that they use. See. See, here we go. If you are a parent completing determine best interest of the child standard, I'm just going to tell you. Under Ohio law, a family court must determine regarding custody the best interest of the child under ORC 3109.04. The court will consider evidence presented regarding custody in light of the factors specified for the best interest of the child standard. So, guess what? This is what I try to tell people. See, all you guys who go into child support, y'all don't play the game. Y'all don't play. Y'all don't know how to deal with child support. See, when my baby mama tried to put me on, I tried to put her on. I filed my own petition for child support. See, that's the name of the game. She tried to put me on, so we tried to put her back on. And the court had to consider both motions. Oh, why you? Because I was arguing this. The best interest of the child standard. I claimed that I had custodialship, and I claimed that I had this and that, and I claimed that I had this and that, and which was true, that my daughter had been living with me. I had other stuff I was arguing. These are the things that you got to understand when you're dealing with your case. So, how many people told you, but we don't do that no more, because that just tie up time and money and energy. That's why I don't really talk about that, because when you do that, you got to be a very thorough litigator. So when you put in that, you got to do all of this, and then you got to file for custody. So I'm just telling you what I did. I ain't telling y'all nothing. I put in a child support petition. I filed for custody, arguing the best interests of the child standard. And we were going through this. The court actually wanted us to file joint custody. The mother refused. And this is the stuff that you got to deal with. Mamas be refusing to do all of this. Okay? Mamas be refusing to work with the fathers because they want to hurt. Because a lot of times is child support is a weapon. So this is what I did. So that's where a lot of guys, where y'all go wrong. Instead of y'all, she put you on, y'all panic. You should have put her ass back. When she put you on, you put her on. And then you file for custody. You understand? You do the same thing, because they got to look at both cases. And then you ask them to stay the proceedings until you stop. These are secrets that I'm revealing that I never really revealed, because now we doing something different. But let me talk to you all about how they was trying to stop my flow. Let me tell you what they were doing. This is what they were trying to stop me on, these issues right here. But your boy so cold. I was cutting so hard. That's why you're not gonna find too many people that litigate. You talk to somebody that's boots on the ground. I could put several people, and they can really tell you, like, yeah, they can tell you real talk that Keng El Bey have really, really done some stuff, really, where I live at and with other people. They can really specify. So what they were trying to do, they was trying to stop me from because I couldn't afford the transcripts. They was trying to bust my head. Okay, they was trying to bust my head. So just letting y'all know, this is what I was doing. They, they was working me, but I'm just telling you what I had to do. I was fighting. I never stopped. I never gave up. They was trying to do everything until they had to go back and set me free. So even if they start taking money out your check, you got to stay fighting. So this is what. Anytime you file an objection to a magistrate, objections to a magistrate decision. So this is what they were. This is what they was busting me with. They weren't trying to give me this. I told them I was indigent and I couldn't pay for the transcripts. So anytime you object to a magistrate decision, objection to a magistrate decision, time for filing a party may file written objections to a magistrate decision within 14 days, whether a court has adopted the decision during the 14-day period under 50 rule 53D4E1. If any party files objection, the other party may file objection not later than 10 days and all that. So this is what I was coming under. 53BD3. Objection to magistrate findings. Now, if you ever heard me, you gonna hear what I was doing. Keng El Bey been around for a minute. I've been dropping this science on my blog talk. Been dropping all this science for a long time. So they were trying to stop my flow because I couldn't afford the transcripts. They was trying to force me to pay the transcripts. So this is what I was arguing. As an objection to magistrate factual finding, and it says transcripts or affidavit. Objection to the factual finding, whether or not specifically designated. Then it just lets you know shall be supported by transcript of the evidence submitted by the magistrate relative to the finding, or an affidavit. Let me see. Or an affidavit if a transcript is unavailable. With leave of the court, alternative technology or manners of reviewing the evidence may be considered. The objecting party shall file a transcript or affidavit within 30 days after filing an objection, unless the court extends time in writing for preparation of the transcripts or other good cause. So sometimes I would just ask for extension of time due to me having to transcribe the evidence. The court would grant me. They would grant me 9 times out of 10. I got my extension of time. But I'm just dropping the science. This is what they was trying to stop, and this is what I won my appeal on and had the case remanded back in front of the court. So when you're dealing with your case, you got to understand how to deal with this. So this is what I was arguing. So let me see. Let me pull up. This is something old. And I put this in. I said, defendant moves the court to file an affidavit and attorney method in lieu of the transcripts. Under these cases, defendant requests to use an affidavit to complete the record for review. Defendant is indigent and cannot afford transcripts and evidence. The defendant will review the hearing in accordance to the local rule 10B to allow the truest recollection to file an affidavit for review. Now, if anybody know me, I'm going to type this. Anytime you deal in emotions, you do emotion, okay? Then it go affidavit in support and then you file. Then it'll be with exhibits. So this is how it go. It would go affidavit. It would go a motion. See, a lot of people back in the days. Now we got a whole. Now since I created Ghost in the System, I got a whole better process. But I'm just gonna talk about my case and how I was doing it. So I did a motion. Anytime you gotta always do a motion to move the court. You do an affidavit in support of the motion, your affidavit, and then you do your exhibits and you label your exhibits to support all of this. So this is how I do it: 1, 2, and 3, and they all come together. So you do a motion, and you do a requesting it like this, but this is nothing but a simple motion. I ain't let y'all see all the stuff that I put in. I just broke it down, and then I did the affidavit in support of the motion, and then I did with the exhibits, and I label all the exhibits and everything. Like when I went to look and review the tapes, they give you a sheet, whatever, to fill out, and you fill them out on them days you was there. And I just got a copy of it and got it, and had the clerk sign off on it. So that way I could use it as exhibits and affidavit support, showing that I witnessed, review. Not only was I present at the hearing, but I further recapped and wrote down notes to transcribe to the best of my knowledge. So that was why I was able to do the motion in lieu, because I did it all. I did all of this. I went and reviewed the hearings and did everything, and I was arguing these case laws. Okay, and I did it, and I did it right. Now let me show you something about the local rules. Let me see. That's what I be trying to tell you. It's a lot of cats that be talking that, but you talking to Keng El Bey. You talking about to the dude that was crushing, that's been in the court and did some things. Let me see the local rules. Local rules. Damn, what them local rules? Okay, here we go. Local rules. Let me show you what I was doing with the court. Let me show you how I was breaking them down. Rules, I was using the rules of evidence. You got to follow the rules of evidence. Rule number 16, evidence and exhibits. And then this is what I was doing for them not to deny my case. So let's go down to Rule 9. See, let me explain y'all something. Ain't nobody showing y'all this, because this is what I was doing for real. This is what I was on boots on the ground. I didn't deal with and everything. Only thing I haven't really dealt with was mortgages. But I didn't deal in a lot of different stuff. So let's break this down. Let's break this down. Let's break this down. So inspection of the case. So they let you know a child case file is defined under Supreme Court Rule 26 shall be open for inspection by a parent's guardian or custodian if deceased, next in kin, or attorney or guardian ad litem for any party of any child party to the proceed. Otherwise, such records shall not be available to any person by order or permission of the judge. So you have to go through. So this is what I was doing. Copies of case file. Any person entitled to inspect child case file may request a copy of the document in the file. The clerk shall provide copies as requested accepting official transcripts. Copies shall be provided during regular business hour within reasonable time as determined by the clerk upon the extent of the request. A fee for photocopying may be charged as the court may determine from time to time. So they kept trying to deny me the video. So here we go. Inspection of audio and video, audio and audio visual. You can do this. So this is what I was arguing. This is the stuff that I was putting on the table. This is the stuff that I was dropping. So understand this. It took me a long time to get to this. I was in court for many years. Many years. Not one, not two, not three, 4, 5, 6 years I was in court. See, that was a long time to be dealing with this foolery. So this is what I was dealing with. So I filed a motion in lieu of the transcripts. The court kept trying to deny me. So I had to file an appeal. See? Filed an appeal. I won the appeal. Then the case got remanded. Let me show you something. Let me see if I can pull up the case. Judgment reversed and cause remanded. So this is what happened. My case had to go back in front of the judge. He had to make a decision. So then he remanded it back to the magistrate, and then she gave up on the case, and then I had to deal with the judge only. So just giving you some points on what I was doing and how I was arguing. You understand what I'm saying? We was arguing some stuff. I argue also this. Civil rule, relief of judgment. These are all the stuff that I was doing. I didn't want to do that. Mistake, inadvertence, excusable neglect, newly discovered evidence of fraud. So this is what I was coming under. Any other reason justifying relief from the judgment. So I was lining up my ducks, putting them in a row. So this is just letting y'all know. I'm just giving y'all some stories. I'm gonna come with part 2 because I'm trying to keep the video short. So just letting y'all know, this is Keng El Bey. When it come down to child support, pretty much you ain't gonna find nobody else really as thorough. A lot of cats, they gonna talk about that stuff. A lot of these cats, they don't know. I mean, I'm not knocking most of the people, but I'm just telling you, I'm boots on the ground. Like, I know how to win court cases. Period. So peace and love to everybody. The video is 24 minutes. So I'll get back with you guys soon. Peace. I'm going to be doing part 2 to this video.